Can a promise, just spoken words, actually be enough to transfer ownership of a whole house? It sounds simple, right? But this very question led to an incredible 20-year legal battle that went all the way to the Supreme Court. Let's dive into this fascinating case and see just how powerful a spoken promise can be in the eyes of the law. So, let's just get right to the heart of it. Can you really gift a house with just your words? Without signing a single piece of paper at that exact moment? This was the huge question the court had to answer. All right, to really get the court's final decision, we have to go back to the beginning, to the family at the center of it all. See, this isn't just about some dry legal codes. It's a story about a father, his two wives, and a promise that was made decades ago. And let me tell you, this was not a quick dispute. The whole legal challenge kicked off in 2004 and only got a final verdict in 2024. That's a 20-year fight, people, going through every single level of the court system. Talk about persistence. So how did this whole thing even start? Well, it all goes back to 1991. A father, Syed Mahmood Ali, orally gifted his house to his second wife, Feroza Begum, just with his words. About a month later, he did put it in writing with a registered deed, but everything blew up in 2004 after the father passed away. His son from his first marriage decided to challenge the gift, and that's what kicked off that marathon 2-decade legal battle. Now, this family's challenge wasn't just a simple disagreement. It actually forced the courts to ask some really fundamental legal questions. This is where a personal family story totally transforms into a crucial legal test for everyone. Ultimately, the entire case, with all its appeals and all its arguments, really just boiled down to this one question. Was that oral gift from the father to his wife legally legit? The son was screaming no, and the wife was saying yes. The courts had to figure out who was right. The son's case was built on 3 main arguments. First, he claimed his dad never actually handed over physical possession of the property. Second, he alleged that his father was way too sick at the time to have genuinely signed that confirmation deed. He was basically suggesting it was a forgery. And third, he pointed out that the witnesses to that deed were never even brought to court to testify. Okay, to figure all this out, the Supreme Court had to go back to basics. It had to look at the core legal principles of Muslim law that are all about gifts. And this specific area of law has a name. It's called hiba. So, what in the world is a hiba? Well, under Muslim law, it's a very specific type of gift. It's an immediate, completely unconditional transfer of property. There's no payment, no exchange. A donor simply gives, a donee receives, and that's it. Simple as that. And for a hiba to be legally rock solid, 3 things absolutely must happen. Think of it like a legal checklist. First, a clear declaration from the person giving the gift. Second, acceptance from the person receiving it. And third, and this was the big sticking point in this case, the delivery of possession. If you check all 3 of those boxes, that oral gift is complete and totally valid. But, and this is a huge but, here comes a crucial legal twist. The law is actually really practical, especially when it comes to family situations. A key principle says that if the person giving the gift and the person getting it already live in the property together, the rules for delivering possession, well, they change. The difference here is pretty simple, but it's so powerful. Generally, if you're gifting a property, you have to physically hand it over and get out. But for a husband and wife who are living together, that formal handover isn't required. What really matters most is the clear intention to transfer ownership. That's the key. So with all these legal principles in mind, the 3 essentials of hiba and that special exception for spouses, how did the Supreme Court actually apply them to the facts of this case? Let's get to the final decision. First off, the court zeroed in on that deed of confirmation from back in 1991. They said, look, this registered document is an incredibly powerful piece of evidence. It's basically a clear admission from the father himself that he had made the gift and, crucially, that he had delivered possession. So that one document helped tick 2 of the 3 essential boxes. Second, the court applied that special exception for spouses. It was a perfect fit. Since the father and his wife were already living in the house together, a big formal ceremony of him moving out and her moving in just wasn't necessary. His obvious intention to give her the property was what really mattered. And finally, the court delivered the knockout blow to the son's case. It ruled that the son had no legal right to even challenge the gift in the first place. Now, why is that? Because while his father was alive, the son only had a hope of inheriting one day. It's not a right to the property. It's a concept called spes successionis. Since the father himself, the actual owner, never disputed the gift, the son couldn't just come along after his death and try to undo it. And so the final verdict, after 20 long years, was clear. It was decisive, it was final. The son's case was dismissed. The oral gift stood. So with this huge legal battle finally over, what does this decision actually mean for the rest of us? What are the key lessons we should be taking away from all this? Well, the biggest impact of this judgment is that it provides some serious clarity and legal certainty. For so many families where property is transferred through oral gifts, this ruling really reinforces that yes, they are valid. It clarifies exactly how the rule of possession works for family members living together, which is just incredibly practical and so important. So let's boil it all down. Here are the 4 key takeaways from this landmark case. Number 1, an oral gift, a hiba, is perfectly legal and valid. 2, for spouses living together, proving possession is much more flexible. 3, backing up an oral gift with a written, registered document makes it incredibly strong. And 4, a potential heir can't just challenge a gift that the property owner themselves never had a problem with. This case is such a powerful reminder of how these ancient legal principles continue to shape our modern lives and property rights. It really leaves us with a final question to think about. How are property transfers handled in your own family? And does a ruling like this change the way you think about a simple spoken promise?